In this blog, I am going to focus on one of the pieces of provincial legislation that guides the activities of an estate trustee, the Estates Act Ontario. In my blog Trustee of Deceased Estate, What a Toronto Bankruptcy Trustee Knows, I set the stage by going over some basics when it comes to a deceased estate and while it would be very comfortable with those basic requirements for an administration of a deceased estate. In the blog, Trustee of Parents' Estate, Do I Really Have to? I described why in some cases parents trying to do the right thing by making all their children an estate trustee could turn out very wrong. In this and the next two blogs, I wanted to focus on the three main Ontario statutes that govern the conduct, duties and responsibilities of an estate trustee of a deceased estate. The three statutes that I will talk about are Estates Act, RSO 1990, C, E.21. Estates Administration Act, RSO 1990, C, E.22, and Trustee Act, RSO 1990, C, Key.23. As you have probably guessed by now, in this blog, I will show how a bankruptcy trustee would be very familiar with the workings of the Estates Act Ontario. Provisions a lit is familiar with. Jurisdiction. Section 5 of the Estates Act Ontario states that letters of administration shall not be granted to a person not residing in Ontario. Similarly, a bankruptcy trustee must be licensed by the Superintendent of Bankruptcy in each province the lit wishes to practice in. Posting of security. Section 14(2) of the Estates Act Ontario requires that the administrator appointed to administer a deceased estate may be required to post security as the court might require. Section 5(3)(c) of the Bankruptcy and Insolvency Act, Canada, BIA, states that the Superintendent of Bankruptcy can require the posting of a bond as security. The posting of security is another common area that a lit understands well. Court can appoint. Section 29 of the Estates Act Ontario deals with the appointment of an estate trustee. This section gives the Ontario Superior Court of Justice the authority to appoint an estate trustee. Section 243(1) of the BIA gives the court the power to appoint a receiver. So, assessing the appropriateness of acting as a court officer and providing consent to do so is something a lit is quite familiar with. Accounts to be rendered. Section 39 of the Estates Act Ontario requires the estate trustee to render a just and full account of the estate trustee's activities. The lit is fully familiar with this process. In both a court-appointed receivership and a bankruptcy administration, the lit must submit full and detailed accounts showing its activities, fees and disbursements for approval by the court. This approval process is called taxation. Admitting and disallowing claims. Sections 44 and 45 of the Estates Act Ontario deals with the procedures to be followed in contesting claims made against the deceased's estate. The lit is very familiar with this process. Section 135 of the BIA deals with the admission and disallowance of proofs of claim and proofs of security. Disputes as to ownership. Section 46 of the Estates Act Ontario describes the process for handling the claim by any third party to ownership of personal property in the estate not exceeding $800 in value. There are procedures in the BIA that a lit must follow when faced with claims of ownership of property by a third party which is in the possession of the bankrupt. I hope that in this blog I have successfully made the case that the provisions of the Estates Act Ontario outlining the responsibilities of an estate trustee tracks very closely what a lit does in either a court-appointed receivership or bankruptcy administration. Therefore, the lit is used to acting as a court officer and could very easily perform the requirements and duties of an estate trustee as described in the Estates Act Ontario. If you have any questions about a deceased estate and the need for an estate trustee, whether it is solvent or insolvent, contact the Ira Smith team. We have decades and generations of experience in helping people and companies overcome their financial problems. You don't need to suffer, we can end your pain. In my next blog, I am going to write a similar comparison. It will be about the requirements outlined in the Estates Administration Act and how a lit is most familiar with them also. In the meantime, if you have any questions at all, contact the Ira Smith team.
I hope you enjoyed the video. The Ira Smith team is available to help you at any time. We offer sound advice and a solid plan for starting now, so that you'll be well on your way to a debt-free life in no time. For more information on a no-cost basis, please visit our website or call us. Our website and telephone details are coming right up now.
Oh.